Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. The Small Business, Enterprise and Employment Act 2015 consultation paper was published by the government just a few weeks ago. This confirms the timing of the implementation of some of the key provisions and provides some additional clarity. A couple of the most headline-grabbing changes include the Register of People with Significant Control, the PSC, and the abolishment, with some exceptions, of corporate directors. The PSC will need to include people who own more than 25% of the shares or voting rights, or who otherwise exercise significant influence or control over the company. Now, there is still lots of detail to be thrashed out here in the consultation process, and particularly the guidance on who will be caught by the significant influence category. Will, for example, franchisors of their franchisee partners be caught by this definition? Companies will be required to compile a PSC by January 2016 and make it available to the public by April 2016. The provisions requiring the removal of corporate directors has been delayed until April 2016, and there will then be a one-year transitional period. The case of St Gobain Building Distribution, GBD v Hillmead Joinery, has provided some interesting guidance on how stringent the courts will be on unfair contract terms. In this case, the parties have been trading on GBD's standard trading terms, which contain the following limitations. 1. That GBD would have no liability for any visual defects, except for providing replacement goods if a written complaint was issued within 3 days of delivery. Number 2, that GBD would not be liable for any indirect or consequential losses. And number 3, that the implied sales of goods legislation terms, satisfactory quality and fitness for purpose, were excluded. In this case, it was found that the exclusions breached the Unfair Contract Terms Act, UCTA, and were therefore void. Each case will, of course, turn on its own facts, and some of the key provisions here were that the parties were of unequal bargaining power. The contract was on GBD's standard terms, and no alternative was offered to the warranties provided by the sales of goods legislation. Now, in our experience, we believe that the terms that GBD sought to impose were within standard commercial terms, and it's therefore a prompt to businesses that seek to rely on similar one-sided clauses to review whether they are enforceable. Of course, some of the risks can be removed by careful drafting. Now, whilst on the topic of UCTA, it is worth mentioning one other case that has hit the courts in the last few weeks. Now, this is a case of the University of Wales versus London College of Business. Now, as you may be aware, where both parties are commercial organisations, the first hurdle for a successful UCTA case is for the party seeking to rely on UCTA to show that it was dealing on the other party's standard terms. This case, however, emphasises the point that even terms that have had some negotiation can still be considered to be standard terms. The Competition and Markets Authority has published a report and guidance note concerning online reviews and endorsements. The CMA recognises the value of online reviews, but has flagged a number of concerning points, including businesses paying for endorsements in blogs and other online articles without this being made clear to consumers. The CMA has now opened an investigation into a number of companies. The Court of Justice of the European Union has held in the case of Balkaya v Keisel Abruk and Recycling Technique that company directors and trainees may, depending on the circumstances, be workers for the purposes of Collective Redundancies Directive, and consequently have to be taken into account when assessing whether collective consultation should take place. The Employment Appeal Tribunal has held in the case of Plum v Duncan Print Group that an employee who is on sick leave can carry untaken leave into a new holiday year, or receive payment in lieu if their employment is terminated. But such leave cannot be carried forward indefinitely. European law only requires employers to permit employees to take annual leave within a period of 18 months of the end of the leave year that it was accrued. This case only applied to the 4 weeks leave granted under Regulation 13 of the Working Time Regulations, and not the additional leave allowed under Regulation 13A. The case of Hill v HMRC is a reminder that although in theory it is possible to make a payment of up to £30,000 tax-free for changes in contractual duties as well as termination. In practice, the HMRC is almost never willing to allow the exemption where the payment was only for a change in contract. In this case, Mr Hill's employment contract stated that he would be required to work within a 10-mile radius of his employer's office in Bedfordshire. He was subsequently seconded to a group company and required to work in London. In return for agreeing to this, he was paid a travel allowance. Then in 2010, his employment was transferred under cheaper regulations to the London-based group company. There was also a settlement agreement where his former employer and his new employer agreed to pay him £30,000. Mr Hill argued that the sum was for him agreeing not to sue his employers, so therefore not earnings and should be exempt from tax. The HMRC, however, stated that it was for agreeing to a location change and therefore should be taxed in full. We've been following the holiday pay cases concerning both commission and overtime. A string of cases in this area have debated whether average overtime and commission payments should be included in holiday pay. The principle being that employees should not be disincentivised to take holiday. Now, a recent Northern Ireland Appeal Tribunal case, which does not set a precedent for England and Wales, has provided some additional clarity that regular voluntary overtime should be included in the holiday pay calculation. Now, as a quick recap, here's where we seem to be on the calculation of holiday pay. Commission pay is less certain, and the lead case in the Lock v British Gas is still subject to an appeal. Call-out and similar payments should be included, but not expenses. Regular overtime should be included. There is still some uncertainty on how regular will be regarded as regular for holiday and commission pay. The appropriate reference period for calculating holiday pay is still to be determined, and this may be affected by seasonal working patterns. There is still doubt on whether an employer can argue that the employee has already been compensated by increased pay during normal working weeks. We are awaiting further cases, particularly the Lock appeal case, which should provide some additional clarity on the outstanding points. The Advocate General has given an opinion that mobile workers' working time for the purposes of the working time regulations will start from the time they start their travels in the morning until they return home. In a current Spanish case, the employer had been calculating working time from the time that the worker arrived at their first customer. Now, the Advocate General's opinion is not binding, but is likely to be followed by the Court of Justice of the European Union. In the case of Gary Abrams Limited versus EAD Solicitors, Gary Abrams provided services through his personal service company, Gary Abrams Limited. EAD stopped paying the normal profit share when he reached the age of 62 due to EAD retirement rules, and Gary Abrams Limited brought a claim of age discrimination against the law firm. Now, this is the first case that has tested whether a corporate can bring a discrimination claim, and it's an important one as many employers operate on the understanding that individuals have waived their rights to discrimination claims when operating through personal service companies. The Employment Appeals Tribunal has ruled that in principle a corporate can bring an Equality Act claim. The British Academy of Songwriters, Composers and Authors, BASCA, has successfully brought a judicial review application against the Secretary of State for Business's introduction of the private copying exemption. In October 2014, a copyright exemption had been introduced to allow individuals that have purchased content to make copies for their own private use. The BASCA argued that the directive that allowed the exception to be applied required that compensation be paid to copyright owners if more than minimal harm would be suffered by them. The government sought to defend its position by claiming that copyright owners had already been compensated as private copying had been reflected in the market pricing of the content. The judge, however, found that the evidence relied on by the government had been insufficient. Now, this decision does not strike out the exemption, but the judge will now hear submissions from the parties and determine whether he should refer any of the questions to the Court of Justice of the European Union. The recent unreported case of All Property Claims Limited v Tang has given a stark warning to businesses that for distance sales contracts, it is not sufficient to merely have your terms and conditions correctly drafted, your processes must also be compliant. Now, in this case, All Property Claims had sold its insurance recovery services to Mr Tang in Mr Tang's home, and then provided a cancellation notice by email the following day. The cancellation of contracts made in the Consumer's Home or Place of Work regulations of 2008, which are known as the CCH regulations, however, provide that a notice of cancellation has to be given to the consumer at the time the contract is made. As the notice was provided the day after the home visit in this case, the court found that the contract was therefore defective and unenforceable. This case demonstrates that the requirements of the CCH regulations are strict. Whether a customer has suffered as a result of the non-compliance is irrelevant. This is in contrast to other legislation that allows businesses to cure technical defects. It should be noted that the CCH regulations have now been revoked and that the contracts entered into on or after the 13th of June 2014 have been replaced by the Consumer Contracts, Information Cancellation and Additional Charges regulations of 2013. Similar provisions, however, do apply. A membership organisation of private consultant ophthalmologists has admitted breaching competition law and has agreed to pay a fine of £500,000 to be reduced to £425,000 if it continues to cooperate. The membership organisation had recommended that its members refuse to accept lower fees offered by an insurer, had circulated detailed price lists to be used with insurers, and had facilitated the sharing of consultants' future pricing and business intentions. We suspect that this may not be the end of the story for the membership organisation. It's already agreed to implement a detailed compliance programme and may also face private action claims from any party that has paid higher fees because of collusive practices. Perhaps its biggest concern will be whether its member organisations wish to remain connected with it. Perhaps the most relevant provision in the Modern Slavery Act for the UK business is in the Transparency in Supply Chain provisions, which require commercial organisations to prepare a slavery and human trafficking statement each financial year. They must report on the steps taken to ensure there is no slavery or human trafficking taking place in their business or in their supply chain, both upstream and downstream. It's anticipated that the obligations will be effective from the autumn and that organisations will have until the end of their financial year to produce their first statement. For large organisations, this is likely to mean that work will need to start now. However, we may not see the legislation guidance for a few months yet. We do not yet know which businesses will be caught by the requirements. There will be a turnover threshold, and we understand that this is likely to be 60 million. Since the 9th of July, businesses that are covered by the Consumer Credit Act and fall within the jurisdiction of the Financial Ombudsman Service, FOS, must comply with the EU ADR directive. As a minimum, this means that such businesses must mention FOS by name on their website and provide a link to the FOS website. The Financial Conduct Authority, the FCA, has issued a consultation paper in which it seeks views on new and innovative ways of giving consumers certain pieces of information. The suggestions include using more easy to understand methods of providing information, e.g. bullet points, interactive apps and videos. This consultation gives us some interesting insight into what regulators may be expecting of business in the future, both within and outside of financial services. Thank you for joining us for this month's Commercial Legal Bulletin. Each month we create a video, podcast and a newspaper of our news bulletin. All are available on the LexisNexis blog. So until next month, thank you and goodbye.